Beach Code Enforcement Special Magistrate hearing for July 8th, 2024. My name is Erica Augello, and I am the appointed Special Magistrate to hear today's cases. I am a practicing attorney licensed by the Florida Bar and am board certified in city, county, and local government law. I have been appointed to this position in accordance with the authority set forth in Chapter 162 Florida statutes and the City of St. Pete Beach Code of Ordinances. I am not an employee of the City of St. Pete Beach and do not represent the city here today. And I do not confer with the city's code enforcement officers outside of the hearing process about your cases. It is my role to fairly and objectively review the matters presented. As such, I would like to advise you of certain matters related to today's proceedings. Today's matters will be heard in the order on which they appear on the agenda unless otherwise agreed. Every effort will be made to hear all persons having relevant evidence, arguments, or comment related to the specific case that is being heard. If you wish to speak today, it is necessary that you be sworn in, which I will do momentarily. All testimony given will be done so under oath. In all cases, since the city has the burden of proof, the city will present its case first, and the respondent will be given an opportunity to refute the city's allegations. Formal rules of evidence do not apply to this proceeding. However, I will make every effort to ensure that fundamental fairness and due process is afforded to all parties. After hearing all relevant evidence, I will issue an order. The order will be reduced to writing and all parties will be provided with a copy, so please ensure that we have your current address or email address. Additionally, you are advised that I do not have the authority to grant you a variance, permit, or special exception of any kind. My role is solely to determine whether a city code has been violated and under some circumstances to provide a reasonable time to correct the violation by whatever means are available to you. Please be advised that you may be subject to a fine and a lien may be recorded on your property if the violation is not corrected by the compliance deadline if one is provided. If you wish to present any evidence today, please sign in before you speak at the podium, and it is necessary that you swear or affirm to tell the truth. Therefore, at this time, I will swear in any witnesses. And when wishing to speak today, if you'll please stand and raise your right hand to be sworn in. Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes.
Okay, so sworn. All right, do we have any changes to today's agenda?
Good morning, Special Magistrate Pete Dewar,
Mr. Drew.
Code Enforcement Manager for the City of St. Pete Beach. There are changes to the agenda. Case number 2024-0214. We would like that case continued to October 14th. That's 2024-0214.
Okay, that is.
SWGOM Ltd Partnership.
Okay.
Case I.
You said continued to the October 14th?
Yes, please.
Okay, so that is on agreement of the parties?
Yes, ma'am.
Okay, so that case will be continued to October 14th at 10 a.m., and I will get an order to that effect out.
Thank you. Case number 2024-0089
Okay.
to August 12th. That would be case J.
Okay, so that case will be continued to a date certain of August 12th.
Thank you.
At 10 a.m., and I will get an order out to that effect.
Very good. Case number 2024-0278. That would be to August 12th as well. And that is 278 under H.
H.
Yes,
Okay.
please.
All right, that will be continued to a date certain of August 12th at 10 a.m., and I will get you a written order to that effect.
Thank you, ma'am.
Okay, with no other changes to the agenda, we will move forward to agenda item 3A, case number 2024-0205, City of St. Pete Beach versus Charles Mackert.
Good morning. Thank you, Special Magistrate Louis Cruz, representing the City of St. Pete Beach Code Enforcement. As you know, this is a 60-day extension to apply for and secure a permit. The previous recommended fine was $250 per day from 4/26/2024 until property is compliant, plus $325 for admin costs. The city will be asking that to be assessed if the permit is not obtained by July 19th, 2024.
Louis, could you hold a minute? Let's make sure that this gentleman is hearing you. Is this the case we're referring to, right?
Yes, sir.
Please make sure he's hearing. Can you hear us, Mr. Gray?
Good morning.
Good morning. Can you hear us? I don't know if he can. Mr. Gray, can you hear us? Nice. Speak into that mic, see if he can hear you.
Hello, sir. Can you hear us today?
No.
No, we can hear.
Mr. Gray, can you hear us? No. Where's Jamie? Oh.
Oh, he's muted.
Well, he is, but our audio should be up right to the bottom. Oh, that's the microphone. Can we speak to him through that microphone? Mr. Gray, can you hear us?
Go to audio, make sure it's the right output. The right speaker is being used.
Pass that mic. Pass that mic. Pass that mic. Mr. Gray, can you hear us? Can you hear us now?
Good morning.
Can you hear, Mr. Gray, can you hear us?
You guys hear me?
We can hear
We
you.
can hear you. Can you hear us?
Can you guys hear me?
Yes.
Us answering is not helping him. Check here, right here. Yep. No,
Make sure
unmute it,
it's on the
unmute
right
it,
speaker.
unmute it. Yeah, make sure it's on the right speaker.
Click microphone.
There it is. Mr. Gray, can you hear us now? Mr. Gray? Go back in there. Microphone. Is there a show microphone?
Do Sam.
Yeah, try that. Mr. Gray, can you hear us now? Hello? Nope. Mr. Gray, can you hear us? Jamie, check audio right there.
It's the batteries. May have this and could check. I've changed twice.
Apparently it's the speaker batteries. Mr. Gray, can you hear us?
Yeah.
I don't think it's a microphone.
My apologies, Madam Magistrate.
No worries. Is there, can we call in through the speaker?
Yeah, right?
Maybe that would be easier.
Yeah, I think he can appear on Zoom and call through that phone. Check the corner here. Pull that up. Pull that up right there. The audio's yeah. See if it's on the right speaker. Should be good to go. All right, ask him if he can hear us.
Can you hear us?
I think he's gonna call in.
Or have him call that number.
They already sent him a message.
Should be on. Hello, Mr. Gray?
Hello, Mr. Gray. Good morning.
There you go.
Can you just close this? No. All right, thank
Can
you.
you hear me now?
Yes, we can hear you, Mr. Gray. So the city has requested,
Sorry about the technical difficulties.
no worries. I don't know if you heard what the city had requested, but they had requested that the permit be applied for by July 19th, 2024, and if not, then a daily running fine plus cost would be assessed. And do you have any response to that?
Okay, so as of right now, my client is in the process of getting a temporary fix to address the hole in the wall on the side of his property. We're still in the midst of working out an arrangement with the insurance company to finally close out his claim and get the money to complete his repairs. We sent in our notice of intent to initiate litigation on June 26th, and the carrier came back with a response on July 2nd demanding mediation. The carrier has 90 days from that request to actually resolve the mediation. So he would not be able to make permanent repairs prior to mediation. That being said, he is in the process of getting a temporary repair done, and once I have documentation from the contractor that he's going to use, I'd be more than happy to give that over to the city. I'm not sure if that's going to require a permit for that particular type of work. At this time, I wanted to request an additional 90 days for compliance.
Does the city have a response?
I do have a question for you, Mr. Gray. By you applying for and obtaining the permit, and at least getting that, because once you get that, you get, 90 days, you get X amount of time once you actually apply for the permit to upload everything, do all the back end stuff of the permitting. Will that mess up your claim with the insurance? Because as of today, you have not even applied for a permit in any facet.
Well, at this point, he hasn't even retained a contractor to do the permanent repairs because he doesn't have the money for the permanent repairs yet. And the permit would be pulled by them, which is my understanding of how this works.
Does the city have any response to the request for an additional 90-day continuance?
Matthew McConnell. Unfortunately, Madam Magistrate, I don't know enough about insurance defense. As a lawyer, just as a courtesy, I don't want to do anything to inadvertently have some consequences for what he's trying to do for the property owner. So no, I don't think the city has anything further to say. I think to Mr. Cruz's point, though, is applying for the permit. I think you can do, there's homeowner permits and there's contractor permits. This may be one, but at a minimum, Mr. Gray, if your client can at least reach out to the city and find out what he needs to do to get this permit and whether or not he can apply for it or whether or not he needs a contractor, just so that we're making some progress, we would appreciate that.
Okay. As I mentioned, he is having some temporary work done. I don't know if that would include a permit. I would have to follow back up with Mr. Mackert to confirm, but I would be more than happy to discuss it with him. Perhaps do a call both with he and I and a representative from the city to see what it entails to make sure that he's in compliance. I would like to see that we get some additional time just to give us time to close out this claim, because if we go to mediation and resolve it, then he can start permanent repairs and we can move forward and everyone gets what they need out of the situation.
Mr. Gray, I do have a question. As I'm sure you're well aware, we've had our first major name storm of the year, though it didn't impact the state of Florida. And perhaps that's what prompted these temporary repairs. But in the event that the insurance company is not able to be resolved at mediation and you have to proceed through litigation, throughout that entire process, do you foresee Mr. Mackert's home continuing to have the hole in the side of it? I mean, needing the repairs to be done?
No, that he was going to be doing the temporary repair regardless. He can't continue to have that exposed area in his property. It's leading to additional damage on the interior, so he wanted to have that taken care of. It was just a matter of getting some money together to get that done.
And has he cleared with the city of St. Pete Beach whether or not those temporary repairs would in fact be considered compliance with the city's code?
That I'm not aware of. I do need to speak to him about that.
Okay.
And have a conversation with the city to make sure that we're doing everything correctly.
Okay. Anything further from the city?
I would just like to add one more thing, if I may, Special Magistrate. Just be mindful, Mr. Gray, if he does anything without consulting with myself and trying to get him answers, or with our permitting department, which would be his best bet to contact to get those right answers, If he starts any type of work, it could add additional fees for work without a permit. If he ever in the future tries to apply for the permit, it could cost him more. So just be mindful of that, obviously, as you're here on his behalf.
Understood.
Okay, anything further, Mr. Gray?
Not at this time.
Okay. I am not inclined to grant a full 90-day continuance on this. I do appreciate that the situation that the property owner finds himself in.
Thank you.
I would be willing to go ahead and grant an additional 30 or an additional continuance until the August 12th hearing. And in that time, I think that's going to be the extent of the continuances that I would be willing to grant. I have concerns about, one, I don't make concessions for anyone else that's come before me and has been involved in active or otherwise litigation. So I am willing to be flexible to a point. However, my job is to make sure that if there is a violation of the code, that there's a remedy given, and that it is equitable to both parties. So the city's not inclined to allow for 90 days. I am inclined to allow for an additional 30 plus. So I will say I'm going to continue this case to a date certain to August 12th at the 10 a.m. hearing, noting the city's request for the permit to be applied for, and then I will go ahead and make my determination at that hearing regardless.
Understood.
Madam Special Magistrate, Pete Dewar, Code Enforcement Manager, will that order say to have the permit at that time?
No, the order will say that it is continued to the date certain.
Thank you.
Yep. And I will get that out to all parties involved. Thank you, Mr. Gray. Have a good day.
Thank you very much. Have a great day.
Thank you.
Okay, moving on to agenda item 3B, case number 20240081, City of St. Pete Beach versus 4401 Gulf Boulevard LLC.
Good morning, Madam Magistrate. Stephen Rivera on behalf of the City of St. Pete Beach. This is a status hearing for the 30-day extension to secure a permit to bring the property into compliance for the railing. They have not secured a permit. I have not heard from any of the correspondents from the property, and the property is still in disrepair. So we're recommending $250 from 3/1 plus $325 administrative costs.
Okay. Is there anyone here on behalf of 4401 Gulf Boulevard LLC? Going once, going twice. Okay, seeing as there's no one here on behalf of 4401 Gulf Boulevard LLC, and Mr. Rivera has noted that he has not been in contact with anyone from the property owner, I am going to go ahead and assess the $250 a day fine starting March 1st, 2024, running until the property comes into compliance. Also, the $325 in reasonable administrative costs of the city.
Thank you.
Okay, moving on to agenda item 3C, case number 20240155, City of St. Pete Beach versus Stephen Boyle.
Morning. Stephen Rivera again, on behalf of the City of St. Pete Beach. This was a status hearing on a 30-day extension to obtain a permit for the erection of the permanent basketball hoop. As of today, there's no permit. The basketball hoop's still erected. I have not heard from the respondent.
Okay, no permit has been granted or no permit has been applied for?
No permit applied for.
Applied for at all. Okay, do you know at all if Mr. Boyle had contacted the city?
I believe he's been talking to Brandon Berry, but there's still no permit obtained or even applied for.
Okay, so, and as far as you know, that basketball hoop still remains encroaching into the right-of-way and has been erected in a permanent nature without a permit?
Correct.
Okay. I do not see Mr. Boyle here. Anyone here on behalf of Mr. Boyle? Mr. Boyle or a representative? Okay, seeing no one. And on this one,
There was a 30-day extension. We're recommending $250 from 6/19/2024 plus $325 administrative costs.
okay. All right, I am going to go ahead and assess the $250 a day fine running from June 19th, 2024 until the property comes into compliance, as well as $325 of reasonable administrative costs of the city.
Thank you.
Okay, moving on to agenda item 3D, case number 2024-0283, City of St. Pete Beach versus Gulf West Properties LLC.
Thank you, Special Magistrate Louis Cruz, representing the City of St. Pete Beach Code Enforcement. Case number 2024-0283, Gulf West Properties LLC is the respondent. Violation address 7060 Boca Ciega Drive. Violation description: the property is in violation of sections 98-66, residential and commercial property maintenance, A, B, and 20 of the Code of Ordinances of the City of St. Pete Beach. Case summary: initial inspection 4/29/2024. Notice of repeat violation dated 5/7/2024. Notices of hearing dated and posted on the property 5/7/2024. These are a true and accurate representation of what I have witnessed. The affidavit of posting at 7060 Boca Ciega Drive, May 7th, 2024. Right here is just overgrown grass again on the property, as was previously at 7060 Boca Ciega Drive. Overgrown grass, strewn palm fronds, overgrown weeds, grass, palm fronds. Just different areas of the property that have overgrown grass. Property became compliant May 16th, 2024 at 7060 Boca Ciega Drive. Property owner must continue to, property owner must continue to maintain landscaping and grass on property. Property is compliant. Recommended fine is $500 per day from 4/29/2024 until 5/15/2024, totaling $8,500 plus $325 for administrative costs. And that concludes my presentation. Thank you.
Okay, anyone here on behalf of the property owner, Gulf West Properties LLC? And please come state your name and affiliation with the property owner.
Vicki Dykens, she's just asked me, she's up in Vermont, so she's just asked me to drive by the property and make sure that, things stay in compliance. We're asked for a reduction in that fine. I think it was a miscommunication between her not being here and me trying to figure out what she wasn't in compliance for. She's been aggressively trying to reduce the amount of vegetation around there and keep it in compliant. Tenant is responsible to maintain the lawn. I've given him a couple 7-day notices, and he has, somewhat been taking care of that. I mean, it's time to do it again now, but I have been after him to do that. But she's just asking for a reduction in that time period when it was a miscommunication on what she needed to be done. I think there was a tree that was over the sidewalk that I wasn't really looking at, and once I realized that that's what they were talking about, she had that done immediately.
Okay, and Ms. Dykens, what is your affiliation with the property owner?
Just a personal friend.
Just a friend. And do you have permission to represent her here today?
Yeah, she, got a notary
Okay.
assigning me, appointing me.
Okay, and what specifically was the miscommunication that you're referring to?
Well, I think one of the code violations, I assumed it was the overgrowth of the lawn, but it was an overgrown tree that was hanging over the sidewalk that was never addressed on time.
Okay.
Mr. Cruz would have to kind of verify that, but
Okay, and
once I realized it was the tree, she had that cleared up and raised. And
okay, and did either you or the property owner contact the city to find out exactly what needed to be done?
I think she was in contact with Mr. Cruz, yes. Sheila Hutman, And then I spoke to him a little bit, and, there's always flags over there. The city's always, there's just always, that corner seems to be utilized a lot by workers, and it's just kind of a mess, but she's trying to stay on top of it.
Okay, anything else that you'd like to present on your friend's behalf?
No.
Okay, anything else from the city?
Madam Magistrate, ma'am, if you could just give the cup, thank you.
Could you put on the overhead for me, please, just so we get this into evidence?
Thank you.
Thank you. And yes, what Vicki is referring to is an overgrown tree that was over the sidewalk from the previous case. I sent out notice of repeat violation, which stated exactly what I was asking for. So I don't know what kind of miscommunication it was. As soon as I talked with her, I shortly talked with Vicky because she was out of the state. Then after I had talked with Vicky here, the property was cleaned up and went and did my re-inspection to get my compliance pictures, but I didn't state anything about a tree overhanging the sidewalk during this case.
Okay, right. I do see that the violation notes that it was for overgrown grass. So the overgrown grass was something that was present from the date of the initial inspection, which was 4/29/2024, until the date that you visited the property on 5/16/24?
Correct.
Okay. And at no point before 4/29 and 5/16 did you visit the property and see that the grass was no longer overgrown, is that correct? That was a
No,
long
ma'am.
way to go about that. Okay. All right, thank you.
Thank you.
I am going to find that this is a repeat violation on this property. I do see that my previous order from 11/14/2023 for the violation of the same code section. I am going to assess a fine. Give me one moment. The previous order did not assess a fine on the property, as the property owner did come into compliance before the hearing. Only reasonable costs were associated, so I am not going to assess a fine of $500 a day. However, I am going to assess a fine of $250 a day beginning on 4/29/2024, plus the reasonable cost or administrative costs of the city, which I believe were $325. Is that correct, Mr. Cruz?
Yes.
Okay, I am going to have that run from 4/29/2024 until 5/16/2024, when the property was noted in compliance. And I will get you a order to that effect. And Ms. Dykens, if you can make sure if we have your email address or however the best is to get you the order, or to the property owner the order, so that they have that information.
Well, I didn't put mine down, so if that's good enough, I guess it's good enough, because
I can send it to I can email it out as well, if that's the best way to get the property owner the information.
that or her P.O. box, yes.
Okay, perfect.
I would like to say it is 5/15 instead of 5/16 for the compliance date.
Okay, 5/15,
Yes.
save a day.
Thank you.
Okay.
Thank you.
Of course. Moving on to agenda item 3E, case number 2024-0168, City of St. Pete Beach versus Family International Home Builders, LLC.
Thank you, Special Magistrate. Louis Cruz representing the City of St. Pete Beach Code Enforcement. Code Enforcement case number 2024-0168. Respondent, Family International Home Builders, LLC. Violation address 7210 Gulf Boulevard. Violation description. The property is in violation of Section 46-33 enumeration 2, 9864 general maintenance A, and 98-66 residential and commercial property maintenance A, B, 20, and E of the Code of Ordinances of the City of St. Pete Beach. Case summary. Initial inspection 3/19/2024. Notice of violation dated 3/20/2024. Notice of violation compliance date 4/5/2024. Notices of hearing dated and posted on the property 5/14/2024. These are a true and accurate representation of what I have witnessed. This is the affidavit of posting at 7210 Gulf Boulevard, May 14th, 2024. This is a concrete wall that has graffiti on it at 7210 Gulf Boulevard. Outside storage of trash and equipment on the property at 7210 Gulf Boulevard. Overgrown grass on the property. Most of the overgrown grass was in the city right-of-way, right by the sidewalk. Updated pictures of the graffiti later on. Overgrown grass. Outside storage of trash and equipment still there. The corrective action. Property owner must remove graffiti or repaint to match existing surface, cut and maintain the grass, and remove the outside storage of debris, materials, and equipment. Property is not compliant. Recommended fine is $250 per day from 4/24/2024 until property is compliant, plus $325 for administrative cost. And that concludes my presentation. Thank you.
Okay, anyone here on behalf of the property owner, Family International Home Builders, LLC? Anyone here on behalf of Family International Home Builders, LLC? Okay, seeing no one. I am going to find that the property is in violation of the stated code sections. I am going to provide, let's see, it's mowing the grass, painting a wall, and removal of debris. I'm going to provide 14 days from the date of my order for the property owner to come into compliance. It is the property owner's responsibility to notify the city once the property is in compliance. And then we will reconvene on August 12th, 2024 at 10 a.m. To determine if the property owner has come into compliance with my stated order and assess any fines and fees at that time.
Thank you.
Just to clarify, Madam Magistrate, is it 14 days from today?
From the date of my order, which hopefully will be done today. But hope is a flawed human notion, and so it will at least be this week. Okay, moving on to agenda item 3F, case number 20240014, City of St. Pete Beach versus Stephen G. Parks.
Thank you, Special Magistrate. Lewis Cruz representing the City of St. Pete Beach Code Enforcement. This is case number 2024-0014. Respondent, Stephen G. Parks. Violation address, 420 80th Avenue. Violation description, the property is in violation of sections 98-65, unsightly conditions, 4, and 23.2, residential parking restricted, B, 2, A, B, and C of the Code of Ordinances and the Land Development Code of the City of St. Pete Beach. Case summary, the initial inspection is 4/2/2024. Notice of violation dated 4/11/2024. Notice of violation compliance date 4/28/2024. Notices of hearing dated and posted on the property 5/16/2024. These are true and accurate representation of what I have witnessed. This is the affidavit of posting at 420 80th Avenue on May 16th, 2024. This is the boat stored incorrectly on the property at 420 80th Avenue. Just different angles of the boat. Also, there is an appliance stored outside, which looks to be a fridge. Some updated pictures of the boat still being on the property, as well as the fridge and other appliances. Corrective action, property owner must park boat/trailer in accordance with the regulations set forth for residential parking. If the regulations cannot be met on the property, the boat must be removed. Also, the fridge must be removed as well. I would like to show on the overhead, I have not talked with the property owner, but I did drive by during my inspections and happened to see it at the time this morning. Thank you. That the boat has been removed from the yard. As well as the appliances. So the property is compliant. The recommended fine is $250 per day from 4/29/2024 until 7/8/2024, totaling $17,750 fine plus $325 for admin costs. And that concludes my presentation. Thank you.
Madam Magistrate, may I ask Mr. Cruz a question?
You may.
So this was due to technical difficulties continued from June 10th, which allowed for 30 more days for the property owner to come into compliance. My question is, prior to the June 10th meeting, had you driven by the property and were they compliant at that time?
Not that I could remember. I've driven by, obviously, because I do my inspections out in the field, not that I was fully paying attention to and actually took pictures of. So to my knowledge, this is what I seen, and I stopped today because I was out, because we're having the hearing today, because it was continued, and I did take photo evidence of it being in compliance.
So the property owner did not notify you of coming into compliance prior to the June 10th hearing?
No.
Thank you.
Okay. Is anyone here on behalf of Stephen G. Parks? Mr. Parks or anyone on behalf of Mr. Parks in attendance today? Okay. Give me 1 second to consult Chapter 162. I do believe the statute says that even though the property is now in compliance and you're requesting a fine, I have to set it for a separate hearing to assess the fine. So give me 1 moment just to make sure we don't have to waste anyone's time doing that. Okay, pursuant to Chapter 162.09, upon notification by the code inspector that an order of the enforcement board, or in this case, the special magistrate, has not been complied with by the set time, or upon finding that a repeat violation has been committed, may order the violator to pay a fine in amount specified in this section for each day that the violation continues past the date set for compliance in the code enforcement board order, in this case, the special magistrate's ordered. I'm not inclined, I mean, obviously, there's no, this was continued from the last hearing, but unless there's any argument for counsel, pursuant to Chapter 162, while I do find that there is a violation of the code section and I am willing to assess the fine, I don't believe I can do so until a future hearing.
So if I can turn your attention to 162.07,
Please
so
do.
paragraph 4. 1, 2. So paragraph 4, 3 sentences down. The order may include a notice that it must be complied with by a specific date and that a fine may be imposed and under the conditions.
Under the conditions specified in 162.091, right, which calls for a second hearing to assess fines. So there's nothing that we find ourselves in a predicament to where there's nothing that there's nothing that the property owner can do at this point to alleviate themselves of any of the fines because the property came into compliance prior to the hearing. However, because the city is requesting fines and fees, and I am inclined to award fines and fees as this was continued from the previous hearing, I do believe I cannot assess those fines and fees until a future hearing that's noticed to the property owner that those will be assessed. And they have the ability to come and give notice and opportunity to be heard as far as procedural due process is concerned.
Understood. So I guess just so I understand, the order is going to say if magistrate's going to rule that there was a violation, you did not come into compliance by the date of the notice of violation?
My order is going to read that you did not come into compliance by the date of the violation. You did not also come into compliance by the date of the notice of hearing for the first hearing. You did come into compliance by the date of the notice of the second hearing by virtue of inspection by the city, and a $250 a day fine is going to be imposed at a future hearing. I mean, I'll put it in the order. I just cannot actually impose the fine until notice and an opportunity to be heard. So I am going to find that there is a violation of the stated code sections. I am going to find that a fine and a fee is appropriate. However, I'm not going to impose such until a future hearing on August 12th, 2024 at 10 a.m. And please feel free to write your local legislators and tell them to change that section of the statute.
Thank you, Special Magistrate.
Okay, moving on to agenda item 3G, case number 202400275, City of St. Pete Beach versus Hassani Capital LLC.
Good morning, Madam Magistrate. Steve Rivera again on behalf of the City of St. Pete Beach. This is case number 202400275. Respondents Hassani Capital LLC. Violation address is 3505 Gulf Boulevard South. Violation description: the property is in violation of Section 7896, business tax receipt required, of the Code of Ordinance of the City of St. Pete Beach. Case summary, initial inspections 5/2/2024, notice of violation 5/3/2024, notice of violation compliance date 5/13/2024, notice of hearing dated and posted to the property 5/14/2024. The following is a true and accurate representation of what I witnessed. This is the affidavit of posting. The corrective action, property owner must obtain a business tax receipt. Property is not compliant. Recommended fine is $250 a day from 5/14/2024, plus the $275 for the BTR until the property is compliant, plus $325 administrative costs. And that concludes my presentation.
Okay. Is anyone here on behalf of the property owner, Hassani Capital LLC? Hassani Capital LLC. Anyone here on behalf of the property owner, Hassani Capital LLC? Okay, Mr. Rivera, have you had an opportunity to speak with the property owner at all? Or the
I
business
have
owner?
not. One of the tenants called me that's staying in the property. She said she would let him and his brother know, and I have not heard anything back.
Okay, what type of business is this?
This is going to be a rental property.
Okay. All right, and as far as you know, they are operating their business without a business tax receipt?
Correct.
Okay. And how long does it usually take to get a business tax receipt?
It's very simple. They can call in, they can come in, drop off a check. I mean, maybe an hour max.
Okay, I am going to find that the property owner is in violation of the stated code section. I am going to allow for 72 hours from the date of my order in order to obtain a business tax receipt. If the property owner does not do so within 72 hours, a fine or a fee may be assessed at the next hearing, which will be held August 12th, 2024.
Thank you.
Okay, moving on to agenda item 3H, case number 2024-0247, City of St. Pete Beach versus SunGold LLC.
Morning, Steve Rivera again on behalf of the City of St. Pete Beach. Case number 2024-0247, respondent SunGold LLC. Violation address is 3815 Gulf Boulevard. Violation description, the property is in violation of section 4633(1)(b), 2, and 3, enumeration. 9865-4, unsightly conditions. 9866-A, B, 24, C, and 3, residential and commercial property maintenance of the Code of Ordinance of the City of St. Pete Beach. Case summary, initial inspection 4/19/2024. Notice of violation dated 4/19/2024. Notice of violation compliance date 5/3/2024. Notice of hearing dated and posted to the property 5/14/2024. The following is a true and accurate representation of what I witnessed. This is the affidavit of posting. This is the dead palm fronds on the tree and on the ground. This was the fence that's in disrepair and miscellaneous trash on the ground. Corrective action, property owner must repair/replace the fence where needed. Dead palm fronds must be cleaned up and disposed of, and all trash and debris must be cleaned up. Property is not compliant. Recommended fine is $250 a day from 5/4/2024 until property is compliant, plus $325 administrative cost. I do have some photos this morning that some of the trash was cleaned up and the palm fronds were removed. However, the fence is still in disrepair. The overhead, please. There is part of the fence there. That was actually in part of my presentation as well. A little bit better of a photo there. There's still miscellaneous items behind the fence. This is another angle. This is all right at the entrance, the fence falling over.
And that's a separate section of the fence, is that correct?
So this is, most of these pictures are right at the entranceway coming in, so there's going to be fencing on both sides.
So this is the opposite side of those,
Correct.
of the prior pictures, okay.
Piece of wood that was previously holding up the other portion of the fence. And that concludes my presentation.
And if I may, Madam Magistrate, Mr. Rivera, those are a true and accurate depiction of what you saw, correct?
And these were taken this morning.
This morning.
So just to, in an effort to be transparent, Madam Magistrate, we were working with the property owner, then Mr. Luke LaRoe got involved, jumped on a phone call with me and Steven on Monday. We sent him pictures. They did their best to come into compliance with a portion of it. They asked that him re-inspect, and I forwarded those photos of the re-inspection to Mr. LaRoe and didn't hear anything about potential continuance or any response to it at all.
Okay, can I ask when? Because if those were taken this morning, when did Mr. LaRoe receive that email?
I did another
I sent him-
inspection on the 3rd.
Correct.
Okay.
So we spoke to him on the 1st, the Monday. Wednesday, we got pictures from the client and Mr. LaRoe saying, hey, we're in compliance, please re-inspect.
Okay.
He re-inspected, and I made it a point before the holiday to send them back to him on July 3rd with the pictures of still non-compliance.
Okay, and they were in the same, the fence was in the same state at that time as it is currently?
Correct. And I even put that in the email. It was more so the fence that was in disrepair at this point to bring it into compliance.
Okay. Okay, and so Mr. LaRoe is aware that the property is still not compliant with the city's code?
Correct. The email specifically says property is not compliant and lists pictures.
And that was sent on July 3rd, and to date, you have not heard back from him?
Correct.
Or anyone from his office?
Correct.
Okay. Okay. All right, anyone here on behalf of SunGold LLC? Do not see Mr. LaRoe in the audience. Anyone here on behalf of SunGold LLC? Okay, I am going to find that the property is in violation of the stated code section as the fence is not in, or the fence remains in disrepair as of today's date. I am going to allow for 14 days from the date of my order in order for the fence to come into compliance with the city's code, however that might be. And then we will reconvene on August 12th, 2024 if the property remains in non-compliance and a fine is needed to be assessed. Because Mr. LaRoe has put in that he's noticed that he is representing this property owner, I can certainly send the order to copy the order to Mr. LaRoe, or would the city prefer that I send the order directly to the respondent? I don't know who's been.
Can you do both?
I can do both.
Because I do believe he made a request on the phone call to receive the orders.
Okay, I will send directly to the property owner, SunGold LLC, as well as to counsel Mr. LaRoe. Okay, we have continued case 3I and 3J. We're moving on to agenda item 4A, case number 20240285, City of St. Pete Beach versus Michael A. Zara and Chia-Yi Liang. I'm just going to apologize ahead of time for butchering those names. Mr. Rivera.
Good morning, Madam Magistrate. Again, Stephen Rivera on behalf of the City of St. Pete Beach. Case number 20240285, respondent is Michael A. Zara and Chia-Yi Liang. Apologize if I said that wrong. Violation address is 108 18th Ave. Violation description, the property is in violation of section 20.03B, permitted principles and uses of and structure of the Land Development Code of the City of St. Pete Beach. Case summary, initial inspection 5/8/2024, notice of irreparable and irreversible violation dated 6/25/2024, notices of hearing dated and posted on the property 6/26/2024. The following is a true and accurate representation of what I witnessed. This is the affidavit of posting. This is the ad on Airbnb. This is the reviews. It shows, so May, they were good. 1, 2, and 3 were 3 short-term rentals in the month of April. And then the fourth one shows the violation that's circled. It does say in the first 1, 2, and 3, stayed a few nights, stayed about a week, and stayed a few nights, and the last one says stayed a few nights as well. Corrective action, property can only be rented monthly until April of 2025. Recommended fine is $1,500 for the repeat violation under one review, plus $325 administrative costs totaling $1,825. And that concludes my presentation.
Madam Magistrate, if I may, just clarify the city's position, because you can see the order that was entered on November 7th. So what we were doing is, in 2 zoning districts, you're allowed to do it a minimum of 3 times. Once you do that, it's a violation. So your order found them in violation, and then said that they couldn't rent for less than 30 days until June. They were in compliance with that. They were in compliance for almost an additional year until we found these violations in April. So this is 4. Therefore, the request is going to be that they can't rent for short term until April of 2025 as well.
So basically starting to clock over. Okay,
Correct.
because otherwise if this had been in June and it had been 4 in June, it would be till July of the next year or June of
Correct.
next year. Okay, understood.
And for the record, I did speak with the property manager. He called to apologize, didn't realize it was overbooked.
Okay. Okay, is there anyone here on behalf of Michael Azar or Ms. Liang? Hi. Good morning. If you could please state your name and affiliation with the property owners for...
Vivian Harold, I work for Tech Travel Property Management Company. I'm going to put up here for you the power of attorney. Let me know when you want me to flip the pages over.
Thank you, Ms. Harold.
Absolutely.
Thank you. Thank you. Thank you very much.
There's one more page, sorry.
No worries. Thank you.
Okay. I did make a copy of all the documents for, in case you guys, I don't know if you wanted to take a copy of what I'm going to present. And I made a copy for you as well.
Thank you, if you could.
Do you want me to bring it to you?
Yes, I would appreciate that. Thank you. Mr. McConnell, did you want to take a look at these before?
So I would like to clarify on the call from Brandon Tecklenburg to Stephen. He actually thought that it was because Airbnb has been updating and it appeared as if maybe there was advertising for less than 30 days, and that's initially what we thought the violation was for. So on that call, if you pull the recording, Brandon said we had no idea it wasn't at 30 days. We thought everything was at 30 days. So that's what he was apologizing for, not for renting. So it's a misunderstanding. Tim Mulhern actually did 2 reservations on Airbnb. He did the first reservation, from March 1st to April 2nd. So this does last night's, so first night being March 1st to April 2nd. In addition, I brought the Airbnb booking for that, and I'll flip that over when you're ready.
Okay.
Madam Magistrate, the previous page that you showed can you tell me where the dates are?
I'm gonna get there too. If you let me finish, then everything, you'll understand everything.
Okay.
And then I also have the Adobe signed contract rental agreement for those 30 days. And I can flip through all these pages if you want me to. Just keep them.
No, I have them here. That's not necessary unless the city...
And then as you'll see on this message thread with the guest when he was initially inquiring, during the beginning he did mention that he was going to possibly extend his nights, but he wanted to see if he was considering adding several nights, but he wanted to see what the property looked like before doing so. I told him that I couldn't hold the dates because he initially wanted us to put a hold on dates, after which he confirms that he went ahead and booked an additional week through Airbnb, requested that we refund the additional cleaning fee, which we did, and then you'll see that's just checkout instructions at the bottom of the thread. Here is the extension that he did. And these are different, and the reason why I'm pulling both reservations from our software system and Airbnb is because Airbnb was the booking platform, but it ultimately all flows into our property management software. So then you'll see here where Tim booked from the 2nd to the 9th is the same person. Here is the additional Adobe signed contract. Every time a new reservation comes in, new contract gets sent out. And I also brought for you a booking report from our software to show, to show that we've had, so of course you'll see Tim, you'll see David Page actually stayed 55 days. Tim stayed for the 32, and then he stayed an additional 7. And then we did have those short terms to fill in April. That was our 3 short terms. After which we have a 34-night booking, a 30-night booking, and a 30-night booking, totaling 202 days booked.
Okay. So just for clarification, Mr. Mulhern is the outlier here, where he initially booked for a 7-day period. Is that correct?
No, he booked for, I think it's 32 nights initially.
Okay, so he booked for the 32 and then added the 7 onto it. But the way the
Correct.
system works is that's considered a new booking, not an extended stay.
On Airbnb, it's a little bit different. They can, if you either you have to send an alteration request to change the dates.
Okay.
And he didn't wait for us to do it, and I guess he didn't know how to do it. I'm assuming that he didn't know how to do an alteration request on his end, and that's why he booked an additional week. Once somebody books on Airbnb, we can't solicit them to book off of Airbnb. It would violate our contract with them. So we can't say, hey, we can book you directly and save you money, because it's through a message system. That would violate our contract with them. And even though we had mentioned doing an alteration request on Airbnb, he responded saying that he already went ahead and booked the week.
Okay. And then my question to you is, do you happen to know how on Airbnb, the reviews, the categorization where it says something like stayed for about a week, how those get, do they select those? Do you know? Or
Airbnb does that. I don't know how it's done. Actually, they've actually done a lot of recent updates. They've redone the entire platform with no instructions on how to do anything. So, but it's not the first time that I've noticed something like that. We have, we had somebody stay at another property and it did the same thing. So, and I mean, I can show you examples, or like, let me see if I have any examples here, just because I know you guys have. So I think George has stayed for 8 nights, but his said he only stayed a few nights too. But for me, that would be a week. So I don't know how they do the system now. I've obviously put in grievances about how they're doing things, amongst other things that they changed, like our OTA connections, the way they connect properties. They're not always displaying them. So I have my own grievances with Airbnb and all their updates, but there's no real representative for the host side. So I'm kind of just getting whoever's answering the phone, and whether they know, they know, and if they don't, they don't.
Okay.
I mean, I can talk to one of the reps the next time we go to one of their conventions. Really, that's the only time you get a one-on-one with an Airbnb rep, but I don't really have answers.
To see how they come up with the categorization. Okay. Anything else, Ms. Harold, that you?
But I mean, if he responded, it is, since he did it in 2 separate reservations, what I'm assuming, and I'm saying assuming because I don't know, I'm assuming that maybe he responded to the last
to write his review.
Notification that he got, and since the one was before that, I'm not sure.
Sure.
But we have been working hard to make sure that we're up and up. Haven't seen you since 2022, if that says anything, and just working hard to be good community employees and representatives and doing everything we need to do.
Thank you, Ms. Harold. Anything from the city?
No, Madam Magistrate. I think with this, the only thing the city would request if you are going to enter an order is that they can't rent until April of 2025, since they've admitted that they've used their 3 this year.
Okay. I mean,
I don't know how you feel about that.
I don't have a problem doing it. I'm not going to find that there is a repeat violation based on the evidence that was presented by Ms. Harold. It's competent, substantial evidence demonstrating that the person who left the review did in fact rent for an additional 7 days, and due to the limitations through the booking channels, It was not two separate rentals, it was a single rental that existed for more than 30 days. So I will not find that there's a repeat violation, but I can certainly do an order stating that there's
And
no...
I have no objection to that.
Okay,
So
then I will go ahead
I'm
and,
fine with that.
yeah, that there is no repeat violation, but again, for the stated code section, the property owner cannot rent for a period of less than 30 days until April 2025.
Sounds great.
Thank you, ma'am. You can give this to Jen.
Okay, all right, and moving on to agenda item 5A, case number 20240305, City of St. Pete Beach versus Family International Home Builders LLC. I feel like we just did this.
Wait,
Yes, same owners, different violations.
Cool, all right.
Thank you, Special Magistrate Louis Cruz, representing the City of St. Pete Beach Code Enforcement. This is case number 2024-0305. Respondent, Family International Home Builders, LLC. Violation address 7210 Gulf Boulevard. Violation description, the property is in violation of Section 78-96, Business Tax Receipt -required of the Code of Ordinances of the City of St. Pete Beach. Case summary. Initial inspection, 5/14/2024. Notice of violation dated 5/14/2024. Notice of violation compliance date, 5/27/2024. Notices of hearing dated and posted on the property, 6/7/2024. These are a true and accurate representation of what I have witnessed. This is the affidavit of posting at 7210 Gulf Boulevard, June 7th, 2024. This is just basically a screenshot of what our system looks like for the business tax receipt and the total that's owed, whether it's paid up to or not. Corrective action, property owner must obtain a business tax receipt for the business operating on the property. Part of this procedure as well also entails a fire inspection, which was not done. Property is not compliant. The recommended fine is $250 per day from 5/28/2024 until property is compliant. Plus, I would like to make a note that they owe $362.50 and BTR fees, which should be on there as well as $325 for administrative costs. And that concludes my presentation. Thank you.
Okay, and this is an apartment complex,
Yes.
and the BTR expired, is that on 5/16/2023?
Yes. Because they have to renew them each year in September.
And have you had any contact with the property owner or the property owner's representative?
No, not about, for this situation. I've talked about the previous one, but I did not talk to, nobody reached out to me about this business tax receipt.
Okay, and while talking to them about the other one, this didn't come up?
No. It was not addressed at the time. Usually our permitting manager will bring these to us when we start getting towards, we're getting towards September already and they're already back 1 year. So she kind of give us a list on, kind of who hasn't paid their fees yet so we can try to get them in line and get them ready for next year's.
And because this requires a fire inspection, I asked before how long it would take to get a BTR and the answer was hours. I'm assuming that's going to take a little longer for this one?
Probably a little bit longer. I'm not sure how the fire marshal goes about her inspections. I'm not 100% sure her time frame, but I know she could probably fit them in fairly quickly if he were to actually finally reach out. I can give you evidence that our permitting manager did reach out to him and also stated that he did need a fire inspection as well as paying the fees from 2022 and 2023, if you would like to see that.
Okay, so he didn't pay the 362 and change is from his 2022
Yes.
BTR, so he was issued a BTR but didn't pay the fees for it.
Yeah, it looks like he didn't pay the fees in 2022 and 2023. And I'm not 100% sure because I'm pretty sure that fire inspections, when you initially get your business tax receipt, you get that done, and that's part of your business tax receipt when you have a property such as his.
Interesting. Okay, all right.
Would you like to see the email?
No, Mr. Cruz, I am good, thank you. Anyone here on behalf of Family International Home Builders, LLC? This is your second chance. Anyone here on behalf of Family International Home Builders, LLC? Perhaps Mr. Randall? Anyone? Okay. I am going to find that the property owner is in violation of the stated code section. Because this does require a fire inspection, I am going to allow for 14 days in order to secure the BTR. We will come back 14 days from the date of my order to secure the BTR. We will come back on August 12th, 2024 to see if the property owner has come to compliance and to assess any fines or fees that might be necessary.
Thank you, Special Magistrate.
Okie dokie. Moving on to 5B, case number 20240277, City of St. Pete Beach versus Alexander Engelman and Adrian Timmel.
Morning again. Stephen Rivera on behalf of the City of St. Pete Beach. Case number 20240277, respondent is Alexander Engelman and Adrian Timmel. Violation address is 3110 Passigrow Way. Violation description, the property is in violation of section 20.03B, permitted principal uses and structures of the Land Development Code of the City of St. Pete Beach. Case summary, initial inspection 5/3/2024. Notice of irreparable or irreversible violation dated 5/6/2024. Notice of hearing dated and posted to the property 5/9/2024. Following is a true and an accurate representation of what I witnessed. This is the affidavit of posting at 3110 Passigrow Way. This is the Airbnb host information. This shows the reviews. So 1, 2, and 3 were the 3 short-term that were permitted. 4, 5, and 6 show the violations. Corrective action. Property can only be rented monthly until April of 2025. Recommended fine, $1,000 per stay, 3 reviews, plus $325 for administrative costs, totaling $3325. And that concludes my presentation.
Can you, Madam Magistrate, may I? Can we submit the Airbnb policy, and then, Mr. Rivera, have you spoken to the property owner?
I did.
And can you just tell us a little bit about that conversation?
They were unaware of the, that they weren't allowed to do short-term rentals. Much like we've heard here in chambers, ignorance isn't an excuse of the law. And I worked with them. They couldn't make it for the last hearing. They were going to be out of town, so we pushed it to this month. But I have spoken to them.
Have you spoken to them between last month and this month?
No.
Okay.
I'm going to enter the Airbnb policy.
Okay. It will be accepted into the record. Okay, thank you. Okay, is anyone here on behalf of Mr. Engelman or Ms. Timmel? If you'll please come up, please state your name and affiliation with the property owner for the record.
Hi, yes. I'm Adrian Timmel. I'm a property owner. We bought this house in March of last year, and, you know, part of the draw, well, I'll say, on the one hand, we bought it because we love the area. It's tranquility, it's peacefulness, it's quietness, so we completely respect the local ordinances. On the other hand, it was a draw because we knew it would be a good rental. We live in Tampa, so this is just a vacation home for us and our 4 boys. And one of the draws was that we could rent it, and the seller's agent, when we did buy it, you know, made sort of wonderful assertions about how you could rent it all day, and they actually had some short-term rentals on the books when we bought it, which we ended up canceling because we had never been property managers before and didn't have an experience with that, and we were worried about the closing date not working for those rentals on the books. So we did cancel those, but then we did start to rent a little bit, and when Officer Rivera did tell us about the violations, of course, we were very concerned. We want to be in compliance with the law, and not only that, with the spirit of the community. So I'm deeply sorry to take your time today on this matter. I would only request, because as he said, I understand that ignorance of the code is not a defense, but perhaps a reduction in the fine, since this was a first-time offense, and we are committed to, no recurrence.
Okay. Any questions for the respondent from the city?
I do have just one question. Did you register with the state?
Yes, you register, that's part of my understanding is the Airbnb policy, and I know, like, we were submitting taxes, sales taxes to the state and to, I think, local sales taxes as
Okay.
well to St. Pete Beach as part of their Airbnb registration.
Perfect. Thank you. I just wanted to know. No further questions.
Okay. And understanding this is a first offense, and you don't have any short-term rentals scheduled on the books from here on out, is that correct?
Correct.
Okay. Well, aside from the 3 that you're allotted, which will not occur until next year. Okay. I am going to find that there is a violation of the city's code. I'm not going to assess $1,000 per stay, as this is a first violation. I am kind of looking at what the average nightly rate is and how long that was rented, plus taking into the credible testimony of the witness. I am going to assess a $500 per stay fine for the amount of $1,500 for the 3 stays, plus the $325 in administrative costs of the city. I will let you know, though, if there's found in the future, you do get 3 more, and that the property cannot be rented for less than 30 days until April 2025. I give this warning to everybody. If you are found back before me again in the future for a repeat violation, I will not be so kind as to have any type of a reduction in that type of fine.
Understood. Thank you.
And I will get you an order to that effect. Make sure just we have your contact information so I can get that to you.
You do.
All right. Costs. All right, moving on to agenda item 5C. To case number 202408280, City of St. Pete Beach versus William W. Adams.
Morning, Madam Magistrate. Again, Stephen Rivera on behalf of the City of St. Pete Beach. Case number 202408280, respondents William W. Adams. Violation address is 1805 Pasagrove Way. Violations description: the property is in violation of section 4633(1), 2, and 3, enumeration, 9865(4), unsightly conditions, 9872C, 1, 2, and 12, vacant buildings, vacant structures, and vacant unimproved lots of the Code of Ordinance of the City of St. Pete Beach. Case summary: initial inspection 5/6/2024. Notice of violation dated 5/7/2024. Notice of violation compliance date 5/21/2024. Notice of hearing dated and posted to the property 6/25/2024. The following is a true and accurate representation of what I witnessed. This is the affidavit of posting. This is a pile of palm fronds located on the property, stacked off to the side. The construction fence that's falling over. Overgrown vegetation on the property. The overgrown vegetation and silt fence. This previously was a home that was demoed. The demo, I don't have the date off the top of my head, but it's been quite some time now. But that's the reason why there's the silt fence and the construction fence still on the property. And these are follow-up photos. Corrective action: property owner must clean up and dispose of the piles of pond fronds, remove the construction and silt fence, and grass and weeds need to be cut and maintained regularly. The property is not compliant. Recommended fine is $250 per day from 5/22/2024 until property is compliant, plus $325 administrative costs. And that concludes my presentation.
Okay, Mr. Rivera, I did have a quick question on the note on the agenda report, it says that a portion, the north half of the property has inadequate vegetation, and the south half of the property is overgrown. Is that the case from the pictures that you?
No, the initial inspection, half of the property was overgrown and the other half did not have adequate vegetation. However, from my follow-up, we got some rain, stuff started to grow, so I didn't pursue that.
Okay, so now one half of the property is okay-ish, and then the other half of the property is overgrown.
Like 2/3 of the property is
Okay.
overgrown. Based on what I see, I don't really see like an ISR violation or anything like that, but it is knee-high. And then the construction fence and the silt fence and the pond fronds are a concern.
Okay, and have you had any contact with the property owner?
I have not.
Okay. Great, thank you very much. Anyone here, Mr. Adams, or anyone here on behalf of Mr. William W. Adams? Mr. Adams, Mr. William W. Adams. Okey dokey. All right, do you happen to know if there's an active permit on this property at all?
The permit's been closed out for the demo that was done, and there's no open permits at this time.
Okay. All right, I am going to find that the property is in violation of the stated code sections. I am going to give 14 days from the date of my order for the property owner to come to compliance. If the property owner does not come to compliance in the 14 days from the date of my order, we will reconvene on August 12th, 2024, and I will assess fines and fees at that time.
Thank you.
All right, moving on to agenda item 5D, case number 20240292, City of St. Pete Beach versus Mina Investments, LLC.
Thank you, Special Magistrate. Louis Cruz representing the City of St. Pete Beach Code Enforcement. This is Code Enforcement case number 2024-0292. Respondent, Mina Investments, LLC. Violation address 562 71st Avenue. Violation description, the property is in violation of Section 78-96, business tax receipt required of the Code of Ordinances of the City of St. Pete Beach. Case summary, the initial inspection, 5/10/2024. Notice of violation dated 5/10/2024. Notice of violation compliance date, 5/23/2024. Notices of hearing dated and posted on the property, 6/6/2024. These are a true and accurate representation of what I have witnessed. This is the affidavit of posting on the property at 562 71st Avenue, June 6th, 2024. Again, this is a screenshot of what we have in our system for our business tax receipt fees. Corrective action, property owner must obtain a business tax receipt for the business operating on the property. Property is not compliant. Recommended fine is $250 per day from 5/24/2024 until compliant, plus $287.50 in BTR fees, as well as $325 for administrative costs. And that concludes my presentation.
Okay, Mr. Cruz, I do have a quick question here. Is this the Mina Investments LLC, this property is being operated as an apartment complex?
Yes.
Is it presently being operated as an apartment complex?
To my knowledge, it still is. They did not reach out to me. Nobody called me anything, even with my notice of violation, not with my notice of hearing. So no one has reached out at this time.
Okay. There's been other code enforcement activity on this property. I know that there was an appeal taken, I believe, by Mr. Weber on behalf of the property owner, and I cannot recall, I do believe it was with regard to a permit for renovation.
Not for Mina.
I think it was short-term rentals.
Was it short-term?
You're thinking of Lake Merritt. Mina was short-term rentals.
Okay.
So
All right, so then,
what I
okay.
did not confirm, because I was thinking the same way you are, Madam Magistrate, was if it's appealed, everything stayed, they may not be renting it. I could not confirm with Mr. Kenny prior to the weekend.
Okay.
But in an interest of fairness, if you could give them, like you've done, 14 days, because if they come back to me and say, hey, we're not operating a business through the body of this appeal, then technically city would not require a BTR at this moment.
But they would still have to.
If I give them 14 days, that means I'm finding that they are in violation of the city code section. Can you bring back up the list of the BTRs? They were
Yes.
were they current?
show you a little bit better.
Yeah, were they current for this year?
Overhead, please.
So 17, 19, oh, they didn't, or is it a 2-year BTR?
One.
Okay, because I see one in 17, I see one in 19.
Yeah, they paid, and then once that case went on, it looks like they may have stopped paying the business tax
2020.
receipt.
2022.
And there's $250 added on to that from the fees that are allotted to the permitting manager. Statute.
So it's like a after-the-fact permit type thing, okay.
Mhm.
And we haven't confirmed if they're continuously renting this property.
Not to my knowledge.
And to that point, I do want to correct myself, Madam Magistrate. Whether it's continuously rented or rented, the city requires a BTR.
If it's
And,
not
and it's not their
rented at all.
homestead. So you gotta have to, I mean, there has to be a purpose of the property.
Is it a single-family home or are they apartment, like
I believe it's a
Separate units, yeah. I
Is
think
it-
there's 6 units, if I'm correct. It says there, 6. There, but it says 6 there. And they could easily reach out and let us know that they're not, they could reach out because there's emails being sent to them, I sent a notice, I sent it.
Sure, but the city has the burden of proof to prove that they are in fact operating a business without having a business tax receipt. That's where I'm getting hung up. It's not enough that somebody's not here saying, no, we're not. It's more that you haven't proven that they in fact are. Do you know if they're, see, I can't go out and find the evidence on my own. So again, just to solidify, you do not know if in fact they are renting any of those units or operating as a business.
Not to my personal knowledge, no.
But you also know that that property is not homesteaded?
Yes.
Okay. And do you know if those properties are vacant?
I wouldn't be able to tell you. I drive by once in a while. I see people parking there, but it's public parking, so it could be from another area. I haven't seen many cars there, but I have seen cars there, and I can't attest to seeing anybody going in and out of the property.
If I may, Madam Magistrate, before you make a ruling, the city would like to request a continuance to August 12th on this case.
I suspect that you would. All right, is anyone here on behalf of Mine Investments LLC? I don't see Mr. Weber or any of his colleagues here. Okay, I am inclined to grant a continuance of this matter until August 12th, 2024 at the 10 a.m. hearing. That will give the city the time to contact the property owner to find out what is happening with this property and also to determine if it does need to be abated until such time as the appeal is done.
Thank you.
Thank you.
Okay, moving on to agenda item 5E, case number 2024-0287, City of St. Pete Beach versus Thomas M. I am so sorry, Cudahy, revocable trust, and Thomas M. Cudahy as trustee.
Thank you, Special
Did I do a
Magistrate.
good job? Okay, great, thank you.
I might not be the same, so. This is code enforcement case number 2024-0287. Respondent, Thomas M. Cudahy, revocable trust, and Thomas M. Cudahy, TRE. Violation address, 7801 Bocasega Drive, number 5. Violation description, the property is in violation of sections 98-123.1, permits required, of the Code of Ordinances of the City of St. Pete Beach. Case summary, the initial inspection was done at 5/9/2024. Notice of violation dated 5/10/2024. Notice of violation compliance date 5/31/2024. Notices of hearing dated and posted on the property 6/6/2024. These are a true and accurate representation of what I have witnessed. This is the affidavit of posting at 7801 Bocasega Drive, number 5, June 6th, 2024. This is an unpermitted tiki hut / gazebo that was erected in the rear of the property. Just going to give you different shots of the unpermitted gazebo or / tiki hut. Different materials that were there that they were using for the tiki hut. Corrective action, property owner must obtain proper after-the-fact permit for the tiki hut / gazebo that was erected without a permit. Property is not compliant. Recommended fine is $250 per day from 6/1/2024 until property is compliant, plus $325 for administrative costs.
Mr. Cruz, assuming, and a big assumption, that this structure falls under an exemption to the Florida Building Code, what section of the city's code, I do see it here, that even if, maybe a floodplain or a floodplain permit or something like that, is there another type of permit that needs to be applied for by the property owner aside from a building permit?
Basically, they would probably have to go through our planning and zoning officials, make sure that the setbacks and stuff like that, that they're using the right materials, that it's anchored properly. We've had cases such as this where you've had to get a variance for it, which someone did, but you have to get
From the zoning perspective?
Yeah, from the zoning perspective. Yes, ma'am.
Okay. Anything from me, Ms. McCall?
You beat me to it, but the city's point of view is, while it may be exempt, we haven't had the opportunity to determine that because it was erected without asking.
Sure. Okay. Anything further from the city?
No, ma'am.
All right. Mr. Cudahy? Good morning. What would you like to tell me about your tiki hut, sir?
We built a tiki hut. I was told I did not need a permit because I had a Seminole Indian there, supposedly. The group that built it came out of Fort Myers. They said I did not need a permit. The city said I needed a permit. I have applied for a permit since then,
Okay.
and I believe that's still in review.
And when did you apply for the permit?
2 weeks ago.
2 weeks. Okay. Okay. For your edification, Seminole Indians do not fall under the Florida Building Code exemption for tiki huts.
That's what I've learned.
It's very nice for them, and that does exempt you from the Florida Building Code unless you've got electricity or water or something running to
None of
it.
that, no.
Perfect. Okay. Anything from the city? Do you have any questions for the respondent?
No.
Okay. Mr. Cruz, any indication of how long a planning review is taking these days?
To be honest, I don't know. Not that I can speak on.
Understanding it shouldn't be going necessarily through it might have to go through the building department.
Correct.
Okay. I am going to allow for 30 days, understanding you've already had 2 weeks with the planning review or the permits being submitted, because it does likely have to go through the building department, and I've kind of gathered with the new building official, things are moving forward, but there's a lot going on. I'm going to allow for 30 days from the date of my order in order for you to secure the permit for the tiki hut, which will put us past the August 12th date. I'm pretty sure. So we will reconvene on September 9th, 2024 to determine whether or not you were able to meet that date, and if not, whether or not fines or fees will be assessed at that time. And I will get you an order to that effect. Just make sure we have either your right email address, your proper mailing address.
Mailing address, you have
Mailing
that.
address, perfect, okay. And then,
You'll mail me that?
I'm sorry?
You're gonna mail me all that?
I will mail you a copy of the order, so you will have that information in there. Okie dokie.
That's it?
That's it for today.
Thank you, sir.
Thank you.
Moving on to agenda item 5F.
Thank you, Special Magistrate. Louis Cruz representing the City of St. Pete Beach Code Enforcement.
Give me a second, just for the record. Case number 202400111.
Yes.
City of St. Pete Beach versus Colonnades Apartment Condo Association.
Perfect, thank you. Respondent, Colonnades Apartment Condo Association, violation address Sunset Way, parcel number 36-31-15-17525-000-0001. Violation description, the property is in violation of Code Section 98-123.1, permits required, of the Code of Ordinances of the City of St. Pete Beach. Case summary, initial inspection, 2/6/2024. Notice of violation dated 3/13/2024. Notice of violation compliance date 3/22/2024. 2024. Notices of hearing dated and posted on the property 6/5/2024. These are a true and accurate representation of what I have witnessed. This is the affidavit of posting at the property of Colonnades Apartment Condo Association on Sunset Way, June 5th, 2024. This is a 2017 Google image of old or previous fence that was there. This is a 2018 Google image of unpermitted fence. Looks like they started to update it and just didn't finish the rest. But by 2019, there is a Google image of it being completely redone on the back units there in the common area. These are my specific pictures that I have taken of the fence that did not get a permit. Corrective action, property owner must obtain proper after-the-fact permit for the fence that was erected without a permit. Property is not compliant. Recommended fine $250 per day from 6/1/2024 until property is compliant, plus $325 for administrative costs. And that concludes my presentation. Thank you.
Okay, Mr. Cruz, any reason, and it's just for my edification, why it took the city so long to find the violation?
This was a little bit of a doozy for me. They had a wrong address. They had an incorrect address that wasn't even a real address, which was 52C Corey Avenue. So I had to go around making calls, trying to get a hold of someone from the HOA, one of the unit owners. So it took me a while to actually get them. Then I talked to an HOA president, started thinking that we were coming into some type of progress, gave her the update, gave her all the information that needed to be done. Boom, new HOA president. Now I had to deal with him. He had no previous knowledge. He had none of the emails that we had corresponded, the previous HOA president and myself had no knowledge, so I had to give him all the information. Talked with the unit owners. They were trying to get in contact with somebody to help get this done. So it took a while. And then once they finally changed the address, then that's when I sent it to that address that was actually a real address that they had on
That
file.
took from 2018 to present?
No, it was just,
My question is, you showed Google images of an fence being erected without a permit in 2017, then again in 2018, then completed in 2019.
Yes.
And here we are at a violation in 2024.
yes, as I had drove by it, it looked so fresh and so new, so I looked into it to make sure that it had an actual permit for it, because it looked so new at the time. They kept it in, good repair after they had made those changes in 2019, 2020, whenever they had finished it there. It looked so new, it kind of stuck out. It looked like brand fresh new. If you can see on the pictures there, it stuck out. So that's why I started the case. I tried to look into it. Then that's when I proceeded to look into it deeper with trying to get a hold of the actual owners or somebody that could help me get in contact with the proper people.
Sure, great, thank you. All right, anyone here on behalf of Colonnades Apartment Condo Association? Okay, if you could please come up and state your affiliation with the association for the record and provide any information that shows that you have the authority to represent the association today.
My name is Ann Allen. I have been an owner at the Colonnades for 34 years. I want to first preface that I am not on the board at this time. I am the only owner that is currently residing at this property right now. And
I'm sorry, Mr. Allen, I'm going to stop you right there. Do you have the authority of the association?
I do not have any authority. I only became aware of this violation as a result of coincidentally finding this notice on the walkway.
Okay, so before you continue.
And I then let the HOA president know about it.
Before you continue, though, just for legal purposes, is anyone here that has the authority to represent Colonnades Apartment Condo Association? Anyone here that has the authority to represent Colonnades Apartment Condo Association? Okay, so then I will go ahead and accept your testimony as a witness and an owner for Colonnade Apartment Condo Association, however, not as the respondent. So.
Yes, thank you very much. I only became aware of this, as I stated, about 3 weeks ago by finding this notice on the walkway. I have been on the board of this association several times, but currently I am not. We are a building of 12 owners. I am on the first floor, which is where the patios have been erected at Unit 1, 2, 3, and I am number 4. I do not have a patio behind my unit. These fencing have been up for well over 10 years. I've been to every HOA meeting in the last 34 years, so I'm very aware of when this became erected. 3 of the units have the patios with the unpermitted fencing. 2 of those units are new owners that bought into the property after the fencing was there, and 1 of the owners has been there and actually organized the fencing being developed. My only concern is we are 12 owners. 9 of us have nothing to do with this, and this would be a fine on all of us. Unfortunately, I do understand it is on common element, so.
Well, and I appreciate your testimony, Ms. Allen. I will say that the property owner is the condo association, and so they are the violator in this context. So, but I will take your testimony into consideration when making my ruling, and if you have any way to get in contact with the association or the president thereof, if you could make sure we get that information.
Yeah, I do agree with Mr. Cruz, because we have had a lot of change in the HOA board in the last year. So I think this notice was probably placed on the door and then of one of the persons that's no longer on the board. So no one knew of this.
Sure. Oh, and then I have a couple of questions for Mr. Cruz at that point. Anything else, Ms. Allen, that you?
No, thank you.
Thank you very much for coming today. Mr. Cruz, in addition to posting on the property, did you send the notice of violation out certified mail to the property owner?
Yes, the first one I sent out because it was taking so long. They said they were going to change the address, said that the property management company at the time, they changed over just recently again. I just sent it to that fake address to show that I sent it to the address that they have on file with property appraiser for the notice of violation. Talked with the HOA president that I was talking to at the time. By the time I was getting ready to do the notice of hearing, because they said they were changing hands of the property, they were getting a survey, they showed me proof of getting a survey, said they were going to have it ready, they already had the contractor ready to go to submit a permit and at least apply for it to get things going. Kind of went on dead. And then that's when I found out it was a new HOA president that I had to talk to, and then he's trying to catch up on all this information that's been going on through my case time that I have there, it just was taking so long. I'm like, I have to do something about this at some point, because they just may keep changing people, different property management companies, different HOA presidents. But I did send it and post it on the property, but I sent it to the new property address that was updated in property appraiser, which was, call of attention to someone at Lamont. I think it was Properties Management Company, something like that.
Yeah, I'm just trying to figure out. I don't have that information, so all I have is the affidavit of posting, which underneath the code is, or underneath Chapter 162, is not sufficient enough unless you've also exhausted your other way. So do you have a copy of the certified notice of mailing?
Yes.
And did you get, when you sent it to the proper address, did you get a signature return?
Not that I can remember off the top of my head. Usually we just get the, the return mail and stuff like that, but I can check and see what I have in my
Thank you.
file here for you.
I do want to make sure they got proper notice.
Because he didn't include the notice of violation. Yeah, but you didn't even include the document.
This was the returned notice of violation that I sent to the property that they had on address at the time, which is 52C Corey Avenue. Yes, and that was returned. And then at the time, they changed their address. And there's the second one there for the notice of hearing. Colonnades Apartment Condo Association, Call to attention Lamont Management Incorporated.
Can I see?
The
is there a way to
overhead.
see the-
Oh, sorry. Can you, yes.
Okay.
So,
Did you need to see the other one, the 52C Quarry? Sorry,
No,
I
I
didn't
just
even know it
wanted to
wasn't
make
up.
sure that the proper address was notified.
Yes,
you
ma'am.
sent this on what date?
And I sent this on. Six 5/2024.
Okay. Anything further from the city?
I can show you an updated view if it'll help. If you need anything additional, I did take every time I do send something, I take like a PDF screenshot of the property appraisal.
Nope, I am
Okay.
good. Thank you
Thank
very
you.
much. Okay, I am going to find that the property is in violation of the stated code section. I am going to again, do you know how long, you've already mentioned this, you don't have any idea how long fence permits are?
Fences are pretty clear cut if they kept it within their setbacks, but again, when you do these things unpermitted, it's hard to know. They might have to change something, it might be too high. I wouldn't be able to.
Got to go through
that.
the association to get a vote
Yeah.
to move this on.
Correct.
You know what, okay, so I'm gonna allow for 30 days in order to apply for and secure an after-the-fact fence permit. This thing has been erected for quite some time. The city has made every effort in order to get the property owner to come into compliance. So I'm going to give 30 days, which puts us after the August 12th date, so we will reconvene on September 9th, 2024. If the property is not in compliance at that time, I will go ahead and consider assessing fines and fees.
Thank you, Special Magistrate.
Thank you. Moving on to agenda item 5G, case number 20240172, City of St. Pete Beach versus NXT Acquisitions Corp.
Madam Magistrate, I know you just read the case. Before we move on.
Sure.
You said 30 days from the date of your order, but then the status will be August 12th?
Will be September 9th. We
Oh.
won't make the August 12th.
Okay, so I'd heard August.
I have learned my lesson on several occasions for that, so
Got it.
just to give a cushion,
Thank you.
September 9th is the better day. But the compliance date will be 30 days from the date of my order regardless.
Got it.
Okay, so case number 2024-0172, City of St. Pete Beach versus NXT Acquisitions Corporation. Mr. Rivera?
Thank you, Madam Magistrate. Stephen Rivera on behalf of the City of St. Pete Beach. Case number 2024-0172, respondent, NSX Acquisitions Corp., violation address 396 41st Ave. Violation description, the property is in violation of section 98-123.1, permits required, of the Code of Ordinance of the City of St. Pete Beach. Case summary, initial inspection, 3/20/2024. Notice of violation dated 3/20/2024. Notice of violation compliance date 4/5/2024. Notice of hearing dated and posted on the property 6/25/2024. The following is a true and accurate representation of what I witnessed. This is the affidavit of posting, 396 41st Ave. This is showing the unpermitted work being done. You see in the background, there's a new electrical panel that was being put in, workers at the property. This is a dumpster full of construction debris. There's broken block, wood, glass. This is some of the unpermitted work. The soffits were ripped out and electrical was being added. Another picture of the soffits. This appears to be a wall that was taken out, or a door. The underside of the upper level was ripped out. Another picture of the windows and doors that were being replaced.
Mr. Rivera, are those air handling units or some sort of mechanical unit that are sitting there?
No, that looks like a plastic tub. Are you talking about right in front? And then the back, if you look up just under the overhang, it's appears to be concrete bags.
Okay, yeah, I see. All right.
And for the record, I did do this inspection. The neighbor complained about the unpermitted work. I did take the building official out with me, so he was there during my time of inspection as well.
Okay.
Everything here would have required a permit. Stop work order that was posted. Corrective action, property owner must obtain permits for the electrical work, pool work, soffit work, drywall work, plumbing work, and window work before any work can be completed. Property is not compliant. Recommended fine is $250 a day from 6/3/2024 until property is compliant, plus $325 administrative cost. When they started the work, there was a permit in review. It was not approved. It was going through an approval process. They were waiting for electrical subs to sign on, things of that nature. And that's why I'm starting the fines from 6/3. Their permit application expired. I have not spoken to the property owner. We did have to go back a second time that day. After we issued the stop work order, they were still working on the property. I advised the workers that I was going to contact the sheriff's office, and they packed up and left after that.
Okay, have you seen, in your driving through, have you seen anyone at the property?
Since this, no, and the neighbor that submitted the complaint hasn't called me either, so it appears that the work has stopped.
Okay, but as of today, there's no active permit?
No, ma'am.
Okay, and so the permit application has expired.
There was a permit application in that was not approved. So it was basically the review process. They need to go through, make sure that everything they're doing is okay, and then they would issue the permit to be active.
Right, so there was no active permit, so the application was in review. Do you happen to know, did anyone, I'm saying it was, the application was expired, meaning that there was no movement on the application.
Correct.
That, building official gave comments or planning department gave comments, nobody responded for a 6-month period.
Correct.
So that's kind of where that permit was, and then it's just closed out now because it's expired.
It's expired, right. And I did make contact with the owner. The owner said, I have a contractor, forwarded me to the contractor. The contractor said, we get permits for everything. I said, okay, and I hadn't heard back from neither the owner or the contractor.
Okay. Thank you very much. Anyone here on behalf of NXT Acquisitions Corp? Anyone here on behalf of NXT Acquisitions Corp? And Ms. Rivera, you spoke to them after you issued the notice of violation?
I'm sorry.
You've spoken to them since the issuance of the notice of violation?
Believe it was, I spoke to them the same day I did the stop work order.
Okay.
I have not heard from them. The permit that they did apply for wasn't even in the scope of work that they were doing.
they were
It was
doing.
supposed to close in a small area, and they went beyond
They would have
that.
exceeded this.
And that's kind of why I put it in my presentation, that they need to obtain a permit for everything that they're doing.
Okay. Okay. I am going to find that the property is in violation of the stated code sections. I am going to allow for 30 days from the date of my order in order to secure the appropriate permits. And then we will reconvene on September 9th, 2024 to determine whether or not the order has been complied with or to assess any relevant fines or fees.
Thank you.
And that's to, in case I didn't say it, it's to apply for and secure a permit for the work that's being done.
Okay. Thank you.
Okay. We are continuing case 5H. And moving on to agenda item 8A under lien reductions, case number 20230616, City of St. Pete Beach versus Anthony J. Brun.
Good morning, Madam Special Magistrate Pete Dewar, Code Enforcement Manager on behalf of the city. The city is going to request from Mr. Perone $10,687.50. He and I just had a discussion. His application basically says zero. He's unable to pay the $21,862.50 that we had originally negotiated. So we're asking for $10,687.50 plus $325 bringing it to a total.
First of all, Mr. Dewar, the city's not asking for anything. This is a lien reduction request that's coming from the
got it.
property owner.
Yes, ma'am.
The last order that I have that you gave to me is an order demonstrating that there was a violation that was $250 a day beginning November 18th, 2023. I'm assuming the property is now in compliance.
Yes, ma'am.
When was that compliance date?
The property, as you mentioned, the property, the fines were assessed November 18th, and the property was complied 5/6/2024 for 171 days, plus the $325 in administrative costs. And like you said, the owner indicated, Mr. Perron indicated zero, that the amount of the lien be reduced to.
But the city is willing to take.
$10,687.50 plus $325
$10,687.50
plus, yes, ma'am,
plus the $325 in fees.
It's for a total of $11,012.50. Thank you.
Sure. Is Mr. Prone here?
Yes.
Sir, if you could come up and explain to me the basis for your lien reduction request?
How do you do, Madam Magistrate?
Good.
My name is Anthony Perrone. I am the owner of the property. I just purchased the property in August of last year. The property was in need of a tremendous amount of renovation. I was told by the person that I contracted with, who has been very nice throughout this whole process, that a permit was not required to replace a door and a window. He admitted that he was wrong about that, and subsequently did apply for the permit, and to my knowledge, the permit, I believe I have it here, the permit was applied for and granted, and the property was inspected and passed inspection. Am I correct in saying all that, Mr. Dewar?
Yes.
Okay, thank you. It took a much longer time than the gentleman that I contracted with to get the permit than he had anticipated. He thought he was going to be able to get that permit very quickly. It didn't work out that way. I did speak to Mr. Dewar on the telephone, and we just spoke outside as well. When I spoke to him about this process, he was very informative and very nice to me, and he told me that there was a procedure to come and request a lien reduction. I did not realize that the gentleman who helped me fill out the lien reduction request put zero in, and per my telephone conversation with Mr. Dewar, I know I have to pay something. There is no question about that. It's my responsibility. I'm the property owner at the end of the day. I have to take care of it. I cannot pay $10,000. I don't have it. I just plead the mercy of the special magistrate to assess something. I mean, I can pay right now $1,000. That's what I can pay right now. Whatever you decide, I'm at your mercy.
I do have a couple of questions, Mr. Perrone. I have not seen you here before, and so what was there a reason that you were unable to appear for the first?
I don't live here.
Okay, so is this your second home or a vacation home?
I'm in the process of retiring from my business, and I'm trying to set myself up down here.
Okay. Okay. And do you recall when the permit was applied for the doors and the windows?
I do recall that we received a notice of violation in December. I was under the impression that the gentleman, which is Equity Realty of the Pinellas, applied for the permit the very next day, but it was improperly formatted. It wasn't signed by a licensed engineer. He signed it as the contractor. He is not a licensed engineer. By the time he got a licensed engineer to actually sign off on the permit, it took till, I believe the day was May 6th.
Okay. Okay. All right, anything further from the city? All right, I am going to grant a reduction in the fines. I am going to assess a $2,500 fine, so it's going to be reduced to $2,500 down from there. I find Mr. Perone's testimony here compelling, but I'm also going to assess the $325 fees. So it will be reduced from the initial amount, which is the
42,750.
Thank you. $42,750. I'm going to reduce it to $2,500 plus $325 in administrative costs. I will get you an order to that effect. If you could please just make sure we have your contact information, email address or otherwise, and you can pay that directly and paid within 30 days.
I was.
That's
that would probably be a good
my
opportunity.
Next question.
Yeah.
How do I pay?
Because I don't want to have what we had last month.
Correct.
What's a reasonable time for you to pay, considering the amount that she's reducing it to?
I can pay $1,000 today.
Okay.
I do have my checkbook with me, and I could pay. How do you want the rest?
Could you get it within a 30-day period?
That's $1,500.
The total would be
no, $1,500 in addition to the 1,000.
It actually
it's
be
28. Actually, it's 1,800.
28.25.
28.20. That's 1,825 additional. I will have that in 30 days.
Okay.
Is a check the only way? Personal check, the only payment method?
We can do wire transfers and.
Oh, what? ACH?
Yeah.
Yeah. I could do that too.
But there's an additional fee for that.
Oh, my bank probably has an additional fee for it too.
Everyone's got an additional fee for it. Okay, so then I will allow for 30 days to pay the reduced lien amount. If the reduced lien amount and costs are not paid within the 30 days, then the order is void and it goes back up to the full amount.
Understood. Thank you so
That will be
much.
on the order that I get to you.
Thank you. I can return today with a check for $1,000 if that's
Yeah,
acceptable.
take that up with the city and we are done here with
Correct.
you.
Thank you. Thank you so much. Appreciate your
Appreciate your
consideration.
patience. Thank you.
Okay, moving on to case number 2023-0513, City of St. Pete Beach versus April Elliott and David Rabarzik. Come on. I almost got it this time. Third time's the charm, right? Okay. Mr. Dewar.
Madam Special Magistrate, the request for this lien to be reduced to is $325. The city is asking for the full amount of $5,500 plus $325 administrative plus $325 administrative, bringing it to a grand total.
So, yeah, Pete, we'll work on.
I'm sorry.
On how to
On the
present
total?
this in the future. I think the application speaks for itself. The only clarity the city wants to make is we had a special magistrate hearing, then we had a hearing challenging the amount, and now we're here today. So the admin costs that the city's requesting at a minimum, which we hope are not reduced, is $650.
Correct.
Now, what Madam Magistrate does with the fine is up to you, but we just want to clarify the fact that.
All right, so the city's asking here today for an additional $325 in administrative costs.
Yes, ma'am.
Okay. Okay. Ms. Elliott, Mr. Rabarzik, would you like to present to me your request for reduction?
Good morning. So I just need some clarification as to what it is the city is requesting today. I understand an additional $325 because this is a second hearing, but are there?
I'll take that right out. I'm not going to be granting the additional $325 in administrative costs.
Thank you. So, but is there any reduction? Are they willing to grant any reduction? That's the part I'm not clear
It doesn't look like it. It looks like they're standing behind the full $5,500 lien plus the $325 in administrative fines. Is that correct, Mr. Dewar? Yes, ma'am.
Okay. Has special magistrate had the opportunity to review my lien reduction application?
I have.
Okay.
But you can certainly go over the highlights for purposes of the record if you'd like to.
I think including my fairly lengthy response to the two questions that were attached to my lien application, have you had the opportunity to review that?
I have.
Okay. Thank you, Your Honor. I just didn't want to belabor that. I guess the points that I would simply highlight then, so I don't simply repeat myself, are assuring the court, I think it is noteworthy that my husband and I really have been proactive in terms of repairs and renovations that we were doing on this building, to include meetings with the zoning department within a week of moving here. My husband and I basically upended our entire family's life in pursuit of a business that we really hoped was going to work out in that space, to the point that I quit my career in Colorado of 18 years to pursue this. We moved our entire family here to pursue this. Unfortunately, the building needed so much more work than we ever anticipated, and after sinking literally hundreds of thousands of dollars into the building, we realized that we could not continue down that path. Obviously, as the court is aware, that building was put up for sale earlier this year. My husband was laid off. I didn't include this into the loan application, but within about a month of me closing my 18-year business, my husband was laid off after moving here. So that also played into the decision of how far down this road can we go? How long can we chase this dream, so to speak? So for us too, as with Mr. Perone, I mean, we are in an extremely dire financial situation at the moment. So a $6,000 fine for something that we truly believe we attempted to be compliant with is a very difficult burden for us to meet. I hate going into that publicly, but that is a fact. That said, as the court is aware, this is our, I think, third hearing to attend in person. At every single one of these, you know, we have watched you ask for respondents to be present, and the vast majority, it seems to be, at every single one are not. And that, as the court is aware, is just not the case with us. We have been present at every single hearing. We do take this very seriously. The one that we missed was on March 11th. I believe, or would like to believe, that had we been able to appear in person, barring my father's health conditions and our kind of emergent trip home the night before the hearing, I think if we had been able to appear here in person, that would have given court further assurance or greater assurance that we were attempting to comply. That is everything that I detailed in my email to Mr. Cruz and to Mr. Rivera the morning of the March 11th hearing, explaining our absence and explaining the fact that we simply were requesting one 30-day extension to get this work underway. From the court's perspective, I understand it appeared as if we were just not here. But in fact, we were trying to appear virtually. We were trying to call in. When those weren't possible, we at least tuned in and watched. We were obviously, therefore, immediately aware of the court's fines. And as the court is aware, the permit application was filed within 3 hours of this court's order, with our GC on this end getting it together, with us being in a very rural part of Texas, driving around trying to find a notary to get the permit done. As soon as the permit was approved, over 3 weeks later, or just over 3 weeks later, the dumpster enclosure was taken down that same day. I mean, there literally was just no faster way for us to have done this. I think that we clearly, perhaps incorrectly, assumed that this court would be willing to grant a 30-day extension at the March 11th hearing. That was our request. Hindsight is obviously 20/20, but we thought that our presence here and letting the court know that we were aware of this, we were taking it seriously, we weren't shirking responsibilities or trying to disrespect the city's codes and laws. I hope that's apparent to this court. And so we are asking to pay the $325, even if the court is inclined to assess another $325 for today's hearing. But being fined $250 a day while a permit is waiting to be approved, and we're constantly texting, constantly emailing our GC, do we have progress, do we have progress? no, I'm calling, we're doing what we can, but at that point, it was just truly out of our hands. Had we gone ahead and torn the structure down, we would have been fined for that, for doing work without a permit. So literally every single day for which we were fined is a day that a permit was pending approval. And immediately upon approval, the work was done within hours. And so we're just, again, I hope that our track record of proactively meeting with the city, at least on 2 prior occasions in person, in addition to a slew of emails with the zoning department before ever doing any work on the building, shows our respect for this city's codes and zoning laws. It was never our intention to not do so. And so we are requesting that the fines be removed, but we are willing, obviously, to pay for the administrative fees for everybody's time for this matter.
Okay, I did have a couple of questions. And correct me if I'm wrong, but I do recall that the reason that a permit could have been pulled prior to when the permit application was first submitted, but wasn't, because the property was listed and there were showings that were happening, and it was your determination that you didn't want a contractor on the property or something of that nature while the property was being shown? Or could you explain, we're not rehashing it here. I mean, obviously this has to do with you guys were in violation. My order on the reduction was pretty clear. My order before was pretty clear. I'm just letting you know that I'm having trouble. I understand and believe everything that you're saying, but I have a problem when you say we've tried everything that we can, we've been present, we tried to comply, and yet for a good period of time prior to the request for the 30-day extension, you had the ability to apply for a permit, maybe not execute on it, but apply for a permit to demolish the fencing area, and didn't do so because the property was listed for sale and was being shown. So what's the rationale for that?
So, and I don't know that it's a rationale. I will say what was happening was my recollection of the court's order when we were here at that first hearing in person, and then obviously there was the written order, was that we were I recall the court saying, well, I understand you're listing it. I don't recall honestly if it had been listed yet or if we were about to, but I know that was part of the discussion. And the specific part of the court order that I recall was confer with Mr. Cruz or confer with the city about what should be done, whether we could paint it, whether we needed to tear it down. So there was a fair amount of debate between us and between our general contractor about which of those courses would have been best. In retrospect, to be quite honest, I wish we'd painted it because then the demo ended up costing over $1,000 between the permit fee and the work. So there's another $1,000 I think we could have avoided had we just painted it. But we did confer with Mr. Cruz. We conferred with our general contractor. We waited for the quote. To be honest, I don't even know if I will just leave it at that. I just remember there being some time spent. I mean, and when we say a fair amount of time, I think we're talking about 30 days between the court's order. Our first appearance with you was in February, was at the February hearing. The March 11th hearing is the one that we were not able to attend. Correct. So that's the period of time that we're talking about. Because our I think the biggest part of the discussion at the February hearing wasn't actually even about the dumpster enclosure. It was more about the fence, if the court recalls.
It was about both, because you had presented evidence to say that the fence was not yours, and I was fine with that.
Right.
My order was dated February 14th, giving you until March 11th to make a good faith effort to come into compliance regarding the dumpster. And you had the ability to do so, and the testimony that was here, understanding you were not, but the testimony that was here was that you didn't even apply for a permit because you guys were showing the property.
We had not at that time, and that's correct. And again, in our assessment, the dumpster enclosure wasn't a risk to anybody's safety. I am not a contractor. I don't know what goes into demoing something like that, but it just seemed better for people to be walking through a safe structure. This was a judgment call that we made, but
and then can I ask, you had the property listed, has the property been sold? Is it under contract?
It is under contract at the time, it is under contract right now. They're still in their due diligence phase of that. Obviously, for commercial structures, that's a much longer process. And for some reason, and this is something Mr. Cruz and I spoke about too, but just another kind of complication of this is a title and lien search was recently done once the building went under contract, and for some reason, this lien is showing up as over $16,000. I don't know why. I did contact Mr. Cruz as well as the title and agency to figure out, and they said, well, it goes with the city of St. Pete Beach. I said, well, that has never been the amount of the assessment. And they said, oh, well, that must be because of a reduction. I'm like, no, it's not. That's still pending. We're set for that hearing today. Mr. Cruz is, it's my understanding from speaking through him, he said that that's an administrative error at some point along the way. I don't know what. But the point is what now we're fearful that that's going to hinder the sale because it appears as though we have a $16,000 lien out on this property. So it's just, this has obviously complicated so many aspects to an already complicated situation. But we are eager to get this taken care of, get this paid. And again, it's our request that this, be reduced to the administrative costs for the time and attention that has been given to this matter.
Okay. Anything further, Ms. Elliott?
I don't believe so.
Anything further from the city?
I just want to clarify one point, Madam Magistrate. We don't include a number when we record these against properties. We just include your order. So that could just be the title company adding up $250 a day.
Well, I was going to say if there's not a compliance affidavit.
Correct. They could just be adding it up from March 11th to today. So I just want you to know we don't put a number on this.
Okay.
So it's not our error that they're calculating.
They would likely be looking for an affidavit of compliance or something else that was recorded, or lien and satisfaction of lien, which it's not been satisfied. So at this point, there wouldn't be anything for them to have an end date on it.
Okay.
And I cannot tell you what to do, but my understanding is you can certainly request some of those things from the city or have a letter submitted or whatnot.
Okay.
That depends on what the city's administrative policies are. I have to say, I appreciate your time. I appreciate you coming here. I appreciate the position that you are put in. I will say I don't have a lot of control over what happens here. I can say I have seen you before. You have requested a reduction. I did consider all of the things that you've told me in that request as well. I took liberties to make things equitable in the interim. I gave time, I gave flexibility, so I don't know that there's much more that I can do based on the exact same information that I've had before. I will not be granting the additional $325 in costs because I don't believe I have the ability to do so underneath the city's code provision. It just says that my task here today is to consider a reduction in the lien, not to assess additional costs for this hearing. So my ruling is going to be I will not be reducing any of the lien amount or the administrative fees. The total amount is going to be the $58.25. Understanding the property is under contract, I usually give about 30 days to pay that. Will that be sufficient for you? Do you think you'll need additional time, less time?
If we can have additional time, it would be really appreciated. It's this building has been under contract once before.
Okay.
And it's our understanding that commercial property, that this is apparently quite common, is that people go in and out of contract frequently. This is what I've been told by multiple realtors, for financing reasons, for work that needs to be done on the property reasons, right? The due diligence unearths, I guess, a lot of different things potentially. And so I don't feel comfortable banking on the fact, while I very much hope that this sale actually goes through as planned, I don't know that that's going to happen. And
How much time would you request to pay?
60. If the court's willing to give 60, we would appreciate that. But obviously, it's going to have to be taken care of at the time of closing.
At any
So
rate, okay.
we're going
Any objection from the city or any response from the city on the timing?
Just out of courtesy, I would request that timing is okay, but at least notify us 10 days before closing because, I'll get called the day before to release a lien and I just need time to prepare it.
Okay. And how far in advance? A week?
10. 10 days.
I'll put that in my order. So I will grant the 60 days from the date of the order in order to pay the fine amount. And then just with the caveat, obviously, that as a courtesy, notify the city 10 days prior to closing so that they can prepare the satisfaction or release of lien, whatever needs to be prepared. Okay.
Correct. And I have no problem communicating directly with your title company.
Okay, thank you. Do
Yeah.
you have a card or how?
Yes.
How should I?
I do.
Yeah,
I can, I don't have it on me, but I can get you one after the hearing, unless Ginny has one.
And truly, good luck to you, Ms. Elliott and Mr. Barczyk. I hope that whatever you guys have going on in the future is easier than this.
Me too.
So,
We have one more. Case number 20190-452, City of St. Pete Beach versus Ling Lei and Zai
I
Yi.
got this, Pete. I'll handle this one.
You got it.
Property owner's not here.
I gathered.
Yeah, so the city is asking if we're not agreeable to reduction.
Well, yeah, I mean, that sounds about right. No reduction is granted. I will go ahead and get an order to that effect. Well, just for the record, is anyone here on behalf of Ling Lei and Zai Yi? I mean, I know I mispronounced that incorrectly, but there's nobody here for the record. Okay, no one here. I will not be granting the lien reduction request as nobody has appeared. And I will get an order to that effect.
Okay.
The next meeting is scheduled for August 12th, 2024 at 10 a.m. here in this building.
I do have one question before we end, Madam
Sure.
Mayor. Procedurally.
Yes.
So, from the city's point of view, we're not asking, generally speaking, not specific to a case, we're not asking for admin cost for lien reduction applications. But moving forward, we would like to ask for admin costs when they challenge the amount of the lien.
If you can provide me for legal backing under either 162 or the city's code where I have the authority to assess that, I can certainly consider
Okay.
it and do so in the future. I just don't know that I have the authority to assess additional administrative costs. I can assess, and then, like I said, it may not be additional. In this context, I know underneath your code, I don't have the ability
Correct.
to. And Chapter 162 doesn't really contemplate this type of a proceeding
Correct.
for lien reductions. In the future, for additional hearing time, those types of things, I don't know that it would be an additional cost. It would just be that maybe during the administrative portion of the hearing, that first hearing, you say it's $325, but by the time we get to the imposition of fines and fees, you've put extra time into it, so maybe your admin costs go up. I just need proof of what those costs are.
Got it.
Okay.
And then I can certainly consider them under Chapter 162 and assess them at that time. As far as the challenge to the fine amount, if you find me something in your code that says I can consider that, then
Okay.
let me know. But there's nothing in 162 to my knowledge
About challenging that.
yeah, those are all out of 162 and all
Code
portions
specific.
of your city's code, so.
Okay.
So it's not a matter of you doing anything additional in terms of the administrative costs. These are the final numbers.
So my authority comes from Chapter 162 in the city's code. Under 162, I have the ability to assess administrative costs in certain contexts. Under the city's code, I don't have that ability.
Got it.
There's no authority granted to me. So unless there's a change in the code or you can find me something, and maybe there is something that I haven't read, but in the provisions, I haven't seen anything that doesn't already parrot Chapter 162 for the most part. But if there's a provision that allows me to assess additional administrative costs, I'm happy to consider them and assess them if warranted.
Thank you, ma'am.
Thank you.
Anything else?
No, we appreciate the expediency of this.
Okay, well
agenda.
then, August 12th, I will see you all then.
Yes.
Yep. You wrap this
We
up
are
pretty quickly.
adjourned.
Thank you.